All right. Well, thanks for having me. As Deborah said, my name is Kristina Moon. I use she, her pronouns. I'm a senior attorney at Education Law Center in our Philly office. And I'm looking forward to sharing with you all. This is the idea, as Deborah said, the impact that we're seeing on students from all of the calls and inquiries that we are getting from parents and students and community members in school districts across the state, and the analysis and research that we've put together in response to those inquiries and requests for advocacy to their school districts about these various issues. Quick review, I know you all are familiar, so I will speed through Title IX and PHRA, but then focus on the application for a number of issues that we're seeing regarding proposed or implemented policies and practices at the school district level about bathroom and locker room access, name and pronoun usage, sports participation, and a broader kind of comprehensive hostile environment. And then, as Deborah said, leave space for questions and observations from you all as well. I think I'd add that I'm happy to share by email to folks afterwards, like with this recording, if that's the practice, some more comprehensive like advocacy letters and narrative analysis that we've put together for in response to requests from parents. And so these slides are a brief overview, but I'm happy to share those longer analyses with all the case sites and everything included afterward. So I think you all are familiar with the Education Law Center, but about me, as I said, I'm in Philadelphia and I have a student in Philadelphia public schools, but I like to note that I grew up in rural central New York and attended a very small K-12 public school district of just a few hundred students. So I can appreciate the experiences of students and staff in the wide range of districts that we serve in Pennsylvania as well. And we've certainly seen inquiries from the broadest range of districts. To start is just a kind of orientation that every child deserves an education that prepares them for success, provides a safe place for learning, and honors their history and experiences. That's where I and ELC come from. And as we've been looking at these issues, we note that the mission and the non-discrimination policies of every district that I've looked at really are parallel with that mission as well. We know that school districts are trying to and want to have the goal to serve all students and have non-discrimination policies. So we really are, trying to come, I believe that we come from similar perspectives trying to serve all students. And to start really with kind of what this actually is about and is the impact on students. So for example, in the Boyertown case in 2018, the Third Circuit expressly recognized that trans students face extraordinary social, psychological, and medical risks, and the school district has a compelling interest in shielding them from discrimination. That's been recognized by numerous other courts across the country, finding that districts where students experience emotional damage or stigmatization and shame result from that differential treatment. And those policies have been struck by courts because of that substantial and immediate adverse effect on the daily life and well-being of trans students. And importantly, it doesn't have to be this way. Affirming school environments are associated with reduced suicide risk among LGBTQ students. So LGBTQ youth who reported having at least one affirming space had 35% reduced odds of reporting a suicide attempt in the prior year. And another study documented that respecting trans students' names and pronouns was associated with a 56% decrease in suicide attempts and a 29% decrease in suicidal thoughts. So creating these affirming spaces in our schools really is life-saving. And that is the motivating factor for us, and I'm sure you all as well. As I said, real briefly, you all know Title IX applies to all public schools, including charter schools and approved private school placements through the IEP process. Some of the examples that Title IX covers are included here in the list, including athletic opportunities, discrimination in courses and programs, pregnant or parenting students, LGBTQ students, and this hostile environment, which is defined as conduct that's sufficiently severe, pervasive, or persistent, so as to interfere with or limit a student's ability to participate in or benefit from the services, activities, or opportunities provided by a school. I'll note that, as you also know, all school districts must have at least one person designated as the Title IX coordinator. And so these Title IX coordinators really must be educated and trained on as the law changes and is updated. So too must your Title IX coordinators be updated on providing supportive services or navigating the complaint process in response to complaints based on gender identity or expression or sexual orientation that are covered under Title IX. A flag here for the recent Title IX rulemaking. The Federal Department of Education has made very clear that they interpret and enforce Title IX consistent with Bostock, that it does cover sexual orientation and gender identity. Obviously, the public comment period from 2022 was closed in September. We don't have a timeline yet, but I'll note that the prior comments took 18 months to be reviewed and finalized for publication. So we're still waiting. If we can expect at least a similar timeline, I think. And flagging here also, the 2023 proposed rules were published in April, just last month, regarding school sports participation. And I do have another slide. We'll go into a little more detail, but the comment period is open now for those. It's only 30 days and closes May 15th. So the high level note here is that these proposed rules do not require schools to limit students' participation in any way in school sports. And it does prohibit schools from categorically banning trans students from participating in sports consistent with their gender identity. And there's some more guidance that I'll provide as we move through. Also relevant is our state anti-discrimination law, the Pennsylvania Human Relations Act, which obviously prohibits discrimination in public K-12 schools as a public accommodation on a number of protected classes, including race, disability, and sex. And generally, Pennsylvania courts and federal courts within PA have construed the PHRA provisions as identical to their federal anti-discrimination laws. So Title IX, 7, 6, we use those cases when interpreting and applying PHRA as well. Specifically regarding transgender students and discrimination on the basis of gender identity, we have from the PHRC guidance in 2018 that sex discrimination included gender identity and transgender status. Also in 2018, we've got the Pennsylvania Philadelphia County Court of Common Pleas 2018 case, Weibel versus the School District of Philadelphia, that held the school district responsible for indirect discrimination and failing to intervene with peer harassment due to the student's gender presentation. This is following claims under the PHRA, and that court ordered $500,000 of damages against the school district. We also have the updated regulations from December of 2022 that provide a comprehensive definition for protected classes, race and sex. Here we talk about sex to include pregnancy, childbirth, breastfeeding, sex assigned at birth, gender identity or expression, affectional or sexual orientation, and differences in sex development. Those new regs will be effective 60 days from publication in the Pennsylvania Bulletin, which has not happened yet. But in a recent conversation, folks at the PHRC told us that their expected timeline is June for that final publication. And importantly, PHRC has taken the position that the statute already encompassed these protections, but promulgating the regs would give them obviously the force of law. So PHRC has been and will continue investigations consistent with these rules, and the rule change just codifies the way that PHRC has been addressing them. I'll note also here, and I'm happy to link to it in the materials that I share out afterward, a statement from the PHRC that they were aware of and monitoring the increase in policies and complaints about the treatment of LGBTQ students in Pennsylvania schools, including this January 2023 statement about Central Bucks School District. ELC has spoken with PHRC just last month. They expressed significant concern about the policies and practices targeting trans students in some of our districts. And I know, I believe they're on the schedule to come and talk with you all directly as well in a coming meeting. Also note here that just this month, there is current proposed legislation to explicitly include sexual orientation and gender identity in the PHRA itself. That's HB 300, the Pennsylvania Fairness Act, that has passed the House and been referred to the Senate. So getting into some application. Obviously, the legal authority and obligation of public schools and board members must be based on current federal and state law, not a personal preference of the board member, religious perspective of the board member. And this is obviously from the Establishment Clause of the First Amendment that prohibits public schools from promoting or affiliating with any religious doctrine. This is a real foundational piece that we have unfortunately had to continue reminders to school board members based on proposed policies and explicit discussions about the biblical perspective that was being sought for application to proposed policies in some school districts. Regarding the US Supreme Court, obviously we have the Bostock versus Clayton County case from 2020 that found that discrimination against a transgender person in the employment context violated Title VII. Since Bostock, multiple circuit courts, the fourth in the Grimm case in 2020 and the ninth in 2022, Doe versus Snyder, have explained that Bostock reasoning must apply to Title IX due to the similarity in language between Title VII and Title IX. We also have a 2021 DOJ memo applying Bostock to Title IX as well. And then I note here that some other recent action for those of us that try to divine the tea leaves from the Supreme Court. They've twice recently rejected cases challenging school policies that support transgender students. They declined to hear two cases about restroom and locker room access, Boyertown in 2018 and one against the Dallas School District in Oregon in 2020. I think the most recent action regarding trans students from the Supreme Court was an April 6th ruling that a trans girl may continue to participate in her West Virginia middle school's track team while her appeal moves forward. The US Supreme Court declined to start leaving in place the Fourth Circuit temporary injunction that allowed the student to continue to participate while the appeal moves forward. I'm sure you're all aware, many federal courts, including those in Pennsylvania, have recognized and affirmed that discrimination on the basis of sexual orientation, transgender status, gender identity or expression is unlawful discrimination on the basis of sex under Title IX and prohibited by law. So to break this down into some of the common scenarios that we have seen regarding bathrooms and locker room access. Schools cannot discriminate against trans and non-binary students by requiring them to use a bathroom or locker room that does not match their gender identity. The schools can provide a gender neutral bathroom option, but cannot require that students only use that gender neutral, like a school nurse room, nurse's bathroom cannot be the only option that trans or non-binary student is allowed to use. We have the Third Circuit Boyertown case from 2018, where they rejected arguments that a school policy protecting trans students violated other students' rights. So just as a refresher, Boyertown changed their own policy to allow trans students to use the locker room and restrooms aligned with their gender identity. Some cisgender students or parents sued, arguing their privacy rights and Title IX rights were violated by having to be with trans kids in the locker room or restroom space. The Third Circuit reviewed and held that there was no privacy violation for having trans and cisgender students share a space. And it did not violate Title IX because the mere presence of trans students in a locker room should not be objectively offensive to a reasonable person given safeguards and privacy options of the school policy. We have also seen this addressed. So Boyertown came out of the Eastern District. We've also seen this addressed in the Middle District, in the AHV Minersville 2019 case, where a policy limiting a trans girl from using the girls' school restrooms was found for the trans student. They were awarded summary judgment. And in the Western District of Pennsylvania, the Evancho versus Pine Richland case in 2017, where a policy restricting trans students from using the restroom consistent with their gender identity was likely to succeed on an equal protection challenge. I'm sorry, that also came out for the trans student. I don't think I read that correctly. There have been a number of other cases arising in other circuits as well, and all circuits, except for a recent reversal in the 11th Circuit, find for trans students having the right to use facilities consistent with their gender identity. As I mentioned, there was this also recent Supreme Court action denying cert in the Dallas, Oregon case that also found for trans students' rights to continue to participate. We also have, in the bathroom locker room context, a number of Federal Education Department, Office of Civil Rights resolutions finding in the same consistent pattern that school districts must allow trans students to use restrooms and locker rooms consistent with their gender identity. I've provided just a couple here, and there are some examples of the types of resolution requirements that have been ordered, including revising policies and procedures, requiring equitable access for students, as I mentioned, training for staff, some instruction to students, and continuing monitoring and reporting to OCR. Looking at students' right to use of a name and pronoun in school. A teacher's use of pronouns that match a cisgender student's gender identity while refusing to use pronouns that match a trans or non-binary student's gender identity is discrimination on the basis of sex and gender identity. And we break this down in a few different ways to analyze this issue. The first is that multiple courts, including the Eastern District of Pennsylvania in this 2020 case that I provided here, have found in the employment context, for example, that intentionally and persistently misgendering a person constitutes sex-based harassment and creates a hostile environment. So I've got an example here from, as I said, the Eastern District of Pennsylvania. There are also a number of OCR resolutions on this point in the public school context as well. We also look at this issue from the perspective of a teacher who may be refusing to use a trans student's name or pronoun in their classrooms. And importantly, a public K-12 teacher does not have the First Amendment right to discriminate in their classroom. Addressing students in their class instruction is speech within the scope of their job. So that speech is government speech and not protected. And that is all under the Garcetti analysis. There is not a right to concern classroom management or disregard school instructions and a school non-discrimination policy. So this really can't be considered compelled speech because the employer can insist on a teacher delivering lawful non-discriminatory messages. There's no free exercise claim because a non-discrimination policy is facially neutral and generally applicable. And schools have a compelling interest in non-discrimination and protecting trans students' well-being. And again, I'm sorry for the shorthand slides, but I do have some advocacy letters that I'm able to share by email afterward with case sites here. We also look at the right to privacy and some arguments that a school must contact or inform a parent about the school policy or practice of using a student's identified name or pronoun in school interactions. And courts have recognized that sexual orientation and transgender status are intimately private and have found that it's a violation of a person's right to privacy to disclose this information absent a legitimate interest. So FERPA obviously gives parents the right to view school records of their minor children, but it does not require schools to proactively contact parents about any content in or changes to student records. Nor does FERPA require a school to document a student's use of a new name or pronoun in an official school record. The few courts that have looked at this issue specifically look for balancing an interest in parent information and really require an individualized assessment of the potential harm to this individual student if their parents are notified. So one case, for example, spoke approvingly about policy that defaults for a priority of sharing information with parents, but really required an individual assessment and conversation with a student about any concern or danger that they might face if their parents happen to be unsupportive and they were choosing to use a preferred name, an identified name or pronoun at school because the school was an affirming, safe place, but their home was not. That's what we got here. On sports participation. We have some cases in the courts now. I don't think this is an area that's as well developed from what I have been following. There was a district court case in West Virginia that granted a preliminary injunction for a trans girl who was had been prevented from trying out for a team by a state law that was banning trans girls and women from participating in school sports. They found at the district level for the trans student right to participate. And as I said, that's the case that had moved up and was denied cert by the Supreme Court recently. So allowing the student to participate while the appeal goes forward. On the US Department of Education's proposed regulations about sport participation, as I mentioned before, it does open for comment period now until May 13th. It does clearly state that schools would not be permitted to adopt or apply a one-size-fits-all policy that categorically bans trans students from participating on teams consistent with their gender identity. So you have to, it calls for assessing each particular team's sport level of competition and grade or education level. So this, the language effectively suggests that elementary schools and middle schools, and even in many cases high schools, because they're not as competitive, would be prohibited from adopting rules that prevent trans students from participating consistent with their gender identity. So it provides that a school can only limit or deny a student's eligibility to participate in rare circumstances for specifically each sport each level of competition and grade or education level, the restriction has to be substantially related to an important educational objective and minimize harm to any student whose opportunity to participate on a team is limited or denied. There's also strong language about prohibiting schools from relying on justifications that do not reflect important educational objectives and that are transphobic. So schools can't justify an exclusion based on disapproval of trans students, a desire to harm a particular student, a desire to exclude trans students from all sports, adherence to sex stereotypes, or for administrative convenience. So they can't rely on any kind of overbroad generalizations or false assumptions, such as restrictions that assume physical advantages for trans athletes across all sports. So schools would not be able to assume that trans women and girls have the same physical abilities as all cisgender boys and men, for example. And my last section here is just kind of a reminder of this catch-all totality of circumstances kind of claim with the hostile environment, where the complaints and resolutions that I've seen on a kind of hostile environment issue really look at multiple discriminatory policies or practices in the school. Any of these that we've talked about on bathroom access or name and pronoun use or sports participation, as well as other practices like prohibiting pride flags being displayed in school classrooms, or kind of consistent with some of the other issues that we're seeing on book bans or classroom censorship of discussion. If there is, for example, a policy to disallow teachers or staff to mention gender identity or sexual orientation in a school, that can be considered among a number of things in a potential hostile environment claim. Also, certainly, if there is peer student-on-student harassment or bullying that is being unaddressed or ineffectively addressed, those all could go to interfering or limiting a student's ability or a class of students' ability to participate and benefit from school activities. So kind of this catch-all comprehensive look at a variety of policies and really the whole environment in a school. And I repeat here, again, the why for concern about these issues, because we can see, and we certainly hear from the calls and the parents and the students that we are talking with, what a negative impact these type of stigmatizing, even proposed before implemented, policies and practices have on students who have every right, as everybody else, to show up to school and be able to focus on science and math class. But when they have a teacher who refuses to use their name and pronoun and stigmatizes them, or when they are being harassed or stigmatized because their Board of Education is talking about excluding them and students like them from equal participation in school opportunities, they are not able to focus and participate in school the way that they're entitled to. So we bring you back here to remind us all that really, if we can provide affirming, positive, supportive spaces for all of our students, they are much more likely to avoid the really negative self-harm and suicide potentials that this class of students is particularly at risk for, and have better academic outcomes. So I'm sorry, I know I sped through that, but intentionally wanting to be sure to allow some space for questions or comments and discussion from you all.